George Sorkin calling, Matt. It's 10 minutes to 9.
Clark, we're back. Madam Clerk.
Yes, Mr. Weinberg.
Could Mr. Wilshaw's attorney, Mr. Gifferstein, and I have a breakout room?
You want to go back in with him, Mr. Kifferson?
And Mr. Wilshaw, if we could.
Yes, sure. Hold on one second.
Well, not Mr. Wilshaw, Mr. Wilshaw's attorney.
He's not here yet. Oh,
Oh.
wait, he just signed it. He's just coming in right now.
Thank you.
You're welcome.
Good morning. This is Tuesday, February 6, 2024. I am Judge Martin. This is courtroom number 1. Today's docket is exclusively civil cases. If you do not have a civil case, you may be in the wrong courtroom. If you're not sure, you may send a chat or message to either Malachi or Marianne. They are court staff who will help you get where you are supposed to be. If you see an invitation to go into a breakout room, please go there. If you have not already talked to the other side of your case, Marianne might make an effort to get you connected to that other side of the case and into a breakout room to talk. If your other side is not here within 15 minutes of the scheduled start time, your case will be called and we will dispose of it without that person present. That being said, Marianne, is there anything ready?
Hi, Judge. Mr. Wilson did have a chance to speak with Mr. Serkian, and Mr. Wilson is here, but I don't know where the opposing counsel went.
He was having, good morning, he was having trouble with his computer, the audio portion, so I was able to call him and speak with him, but he was having trouble with the audio, so he dropped off. And so we're ready, I guess. What we're asking for is this case involves a dispute over some equipment, and there's some common ground and some potentially not common ground. And
I'm sorry, Mr. Wilson, you're talking about a case that hasn't been called, and just so the record's clear and straight, this is 2301211 GC, Christine Morgan versus Metro Auto and Truck.
Yes, Your Honor, thank you. Getting ahead of myself, I guess. So the the issue involves some property that there's a dispute over, and there seems to be some common ground over what does belong to my client, and potentially that'll help narrow the issues over what is still disputed and what isn't, I guess. So we're what I spoke with and what Mr. Serkian, attorney for Metro Auto, agreed to was for an adjournment for another 60 days to try and sort out those issues, if the court would be willing to entertain that.
Well, Mr. Wilson, my only concern is that the last time we were here, which was on December the 5th, it was only one party present. And for this to be the second pretrial, and we're back where we were previously in terms of there only being one party present.
He was present, Judge. He was having trouble with his computer.
I understand, but on December the 5th, it appears that you weren't here, your client wasn't here. Mr. Serkian was here and requested 60 days discovery. We have now done that. The pretrial was adjourned to this morning. He was logged on and I saw him this morning.
Yeah.
And you're indicating that you have some common ground. How long of an adjournment do you need, Mr. Wilson?
What Mr. Serki and I talked about was 60 days. I mean, if the court wants less, that's fine with us too. I mean, my client would rather see it done too, but 60 is the number that he and I spoke about.
It's your case. If you wanted to go 60 days, I lose no sleep over it. 60 days puts us on the April the 2nd docket. April the 2nd at 9 a.m. We will adjourn over 23-01211 and we'll call it final pretrial / motion date. You don't need to file a motion, but if you anticipate filing a motion, that's the date you should use. And if Mr. Serkian logs back on, we'll give him that date as well. Was there anything else, Mr. Wilson?
It's April 2nd at what time, Your Honor?
9 a.m., sir.
9. Okay, thank you so much. That's all for me.
Thank you. Have a good day.
Okay, thank you. Bye-bye.
So what, I be able to at least go in?
I'm sorry.
Oh, I was talking to my lawyer. I apologized. I was just wondering if I could start going in and getting some of my stuff.
Ms. Morgan, there's been no settlement as far as this court has been made aware of, and Mr. Wilson has logged off.
Okay. So do I just log
So you
off
might
now?
want to give him a call with that question, ma'am.
Okay. Thank you, Ms. Martin. Hey, have a good day and God
Have a good
bless you.
day. Thank you.
Hey, Judge. What was that date again? I was moving Brian Marcus and his client over to room 6. So I didn't catch it.
Malachi, I'm out here making updates. It's April the 2nd at 9 a.m.
April the 2nd at 9 a.m.
Yes, sir.
Thank you.
Thank you. Mary Ann, would you please go see if you can help Malachi?
Sure.
Thank you. This is 23268 GC Citizens Bank versus Robert Watts. May I have your appearance, please?
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff Attorney of Record P72322.
Good morning, Ms. Francis.
Good morning, Judge.
Ma'am,
Your Honor,
today
I
was the
know.
day and time scheduled for the,
Sorry. Sorry.
no, you go ahead.
I know defendant isn't here, but plaintiff did send him a stipulation to dismiss. We just never received it back. So I was just going to ask Your Honor if we could dismiss this case without prejudice.
Ms. Francis, I'll indicate on the ROA that there is a stipulation to dismiss without prejudice forthcoming because Mr. Long did file an answering appearance. I can't just dismiss it. I'll actually set the case, adjourn the case over to our March the 5th docket at 9 a.m. So long as we get the dismissal before that date,
We
we'll
sent
consider
it
the
to
matter
him,
resolved.
back in December, Judge, and still haven't received it, so I'm not very positive we'll have it, but we'll try again.
Thank you, Ms. Francis. Anything else in this case?
No, Your Honor, thank you.
Thank you, ma'am. Have a good day.
You too.
Thank you. This is 2301213 GC. This is Preferred Medical versus Auto Club Insurance. May I have your appearances, please?
Good morning, Your Honor. The court here.
I'm sorry, sir, you're having a little bit of an audio issue there.
Okay, can the court hear me now?
Yes, sir.
Freddie Sackler appearing on behalf of Preferred Medical. Freddie Sackler on behalf of Preferred Medical.
Good morning, Your Honor. Matthew Cohen on behalf of Defendant Auto Club.
Thank you. Today is the day and time scheduled for the second pretrial in this matter. How are we proceeding this morning, Mr. Sackler?
Your Honor, opposing counsel recently sent us a set of discovery. I can't remember what the court said about discovery last time, but we're going to answer it. I don't know if this case, is going to resolve short of just a dead set trial date. I'm sure we will reach a settlement, hopefully at some point, but sometimes having a set trial date or summary disposition motion date will help get things to the end. Ultimately, Judge, my client is a transports people for medical services. We were paid and have been paid, but in September of 2022, the carrier decided to not pay our whole bill anymore. So they're arguing our fees are not the reasonable fees, even though we have, several insurance companies that pay the fees that we charge.
Your Honor, I guess to address everything in totality, the main reason why we sent out the discovery was we were advised by Mr. Sackler at the first pretrial that he'd send over the bills and records. I understand he had a medical procedure, though, shortly after that, so I totally understand why that may not have happened, and I will take some of the blame for not following up on that. I don't believe that this case will go to trial, at least not as of this point. I do think a resolution is possible, but I do need the medical records and bills to match everything up. Not disputing that some payments were made, probably not to Mr. Sackler's client's liking, and that's probably where the issues ultimately lie from what he's telling the court. But I do need that information to at least have a conversation with my client to make sure that we are on the same page with what is outstanding, what was paid, et cetera.
Well, when we were here on December 5th, there was a request for 60 days discovery, which was to commence immediately, which means that discovery should be closed at this point. Both parties had requested a trial by jury, and this court is prepared to schedule that jury trial today. If it's your position, gentlemen, that you have discovery outstanding between you and that you are able to move either towards a resolution or a motion date, please let me know, and we'll schedule this matter for a final pretrial / motion date and give you sufficient time to argue whatever motion you need, not on this regular civil date, but on a different date where you might get into your arguments more. What's your pleasure, Mr. Sackler?
Your Honor, first, counsel's 100% right, and I apologize. I completely forgot about on December 6th, I went into a knee replacement. So I completely apologize if he asked me to informally send that to him. I will send it today. We did get his discovery response 2 weeks ago. We are going to answer it. But if we could get that final pretrial date, final motion pretrial date, that would be great. Because I'll give them the discovery they need, and we can just get to that date and either resolve it in the next 2 weeks or file motions by that final pretrial date.
I do agree with. I'm sorry, I didn't mean to cut you off. I do agree with that, Your Honor.
So we'll call it on final pretrial motion date on March the 19th at 9:00 a.m. Your case is the only case that will be scheduled in a 1 hour block, not suggesting that you need an hour, but just so you know, you will not be rushed. Will that give you sufficient time, Mr. Sackler?
Yes, Judge.
Mr. Cohen, will that give you sufficient time?
That will. Thank you, Your Honor.
March 19th at 9 a.m. Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor. Thank you.
I'll see you next month. Have a good day.
Thank you, Your Honor.
Take care.
Malachi, if it's not already clear to you, I just make up dates and give them out, so.
That's all right with me. I wrote it down, so we're good.
Thank you, sir. I'll note on base at the end of the docket, so. I was looking for 2300699 GC UHG versus Amber Addington. May I have your appearances, please?
Attorney Megan McKelly, P 83877, appearing on behalf of UHG.
Amber Addington.
I'm sorry, ma'am, you need to speak up a little for me, please.
I'm sorry, Amber Addington.
Thank you, Ms. Addington. Today is the day and time scheduled for the first pretrial in this matter. Have the parties had the opportunity to speak?
Yes,
We
ma'am.
have had an opportunity to speak, Your Honor. And if I could note that this is not the first pretrial. The first pretrial was adjourned. And we did adjourn the matter because Ms. Addington advised that she will be filing a bankruptcy.
Oh, thank you for that clarification, Ms. McKelly. Ms. Addington, have you filed bankruptcy in this?
I am still working with my lawyer. I had surgery yesterday. My plan of action from my lawyer, he told me to wait to file it until after I had this surgery. And I had Rectiseal and hemorrhoid surgery yesterday. So,
Ma'am, I'm sorry. So the answer to the question is no, you have not.
no, I'm still working with my lawyer on filing, yes.
Ms. McKelly, how would you like to proceed?
Your Honor, since there's no issue of fact here, she's not disputing this debt. The bankruptcy hasn't been filed. We've given her ample time to do that. So at this time, we'd like to request that a judgment be entered.
Ms. Addington,
Yes, Your Honor.
did you hear Ms. McKelly just now?
I did, yes.
Your response to the request from the plaintiff, ma'am?
Right now, I have a disability case going. I am working on filing.
Ms. Addington,
Yes,
I don't know if the volume on your device is low or if you're having difficulty getting close enough to the microphone, but I can barely hear you.
I'm sorry, Your Honor. It's bad in my house. I'm trying. Right now, the reason I am filing for bankruptcy is because I only get $800 a month and I'm on disability. I am trying to take responsibility for all of my debts, and I am working with a lawyer and trying to take care of all of my rearances. And I needed just a little bit more time. I had to have $400 to file the bankruptcy. And all I can say is I'm working with my lawyer. I've been working with him, and I'm putting in good faith to try to take care of everything.
Ms. McKelly, what we will do, excuse me, is adjourn this matter over to March the 5th at 9 a.m. We'll call it a pretrial / motion date. If you want to file your motion for entry of judgment, we'll hear it that day at that time. Ms. Addington, you should, if you're going to file, you should get that filing done. And then the bankruptcy stay would be filed. Otherwise, Ms. McKelly's office will file its motion once you receive it. If you wish to submit a response, you would have to file it with the court, serve the plaintiff's office as well.
Okay, Your Honor.
Anything else, Ms. McKelly?
Nothing further, Your Honor.
Anything else, Ms. Addington?
No, Your Honor.
Thank you. Then you're free to go, Ms. Addington. I wish you a well recovery.
Thank you very much.
You're
You have a
welcome. Have a good day, Ms. McKelly.
Thank you. You as well.
Hey, Judge, it's me again. March, what was that date?
March 5th at 9 a.m., but Malachi, if you would have waited, I'm putting the notes in.
Oh,
Are
you're
you trying
putting
to
them
do real-time dispo?
in? I was just putting them on the notes on the docket. So then when I go back, because I'm just following the orders around here.
I'll have to come downstairs and find out what those orders are. I'm not aware of them.
She just wanted me to hop on and take the notes and then dispo them after.
You have been on with me before. You should know by now that
I know you usually take notes, but that's just what I was told.
March the 5th at 9 a.m., we'll treat it as a pretrial motion day, and I will not get in the way of your direction from your supervisor.
Thank you.
Thank you, Malachi.
Thank you.
I was looking for Mr. Oh, they're still in the breakout room, so we'll skip that. What? Eddington, Cox. This is 2301788GC. Moore versus LaRoche et LaRoche. May I have your appearances, please?
Good morning, Your Honor. Jeremy Brown, on behalf of plaintiff.
Morning, Mr. Brown. Mark LaRouche. I see that he's here. Don't know why we can't get him unmuted in video. Mr. Brown, did you speak to the defendant this morning?
I have not yet. If you wanted to put us in a breakout room, we could try to speak, but I have not spoken with him yet this morning, though.
Good morning, Mr. Kirschenheiter.
Hi, Judge. How are you?
I am super. How are you?
Not too bad.
Have you spoken to the defendant?
I have not, but I'm happy
Let's
to.
get you moved into a breakout room. I see them here logged on.
What case is he here for, Judge?
He's from Michael Olsey's office, 2302988. Mr. Varchetti, I see you. My policy is usually 15 minutes after the scheduled start time, so if we haven't seen Caraba at about 1:45, I'll get your case called. If there's something else you want to do or go dark in the interim, I understand.
Thank you very much, Your Honor.
This is 2302988 GC, Bank of America versus Gafenchu.
Thank you. Yes, thank you, Your Honor.
Thank you. Your appearances?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
Would you state your name, please?
Petronella Gafencu.
Thank you. Today was the day and time scheduled for the pretrial. The parties have had the opportunity to speak. How are we proceeding this morning?
And Your Honor, we're unable to come to a resolution at this time. I'm not even sure if discovery is necessary. My plaintiff doesn't need discovery. We'll be filing a motion for summary disposition. If I don't know if opposing side needs anything else from us. I just believe it's a situation of financial difficulty.
Ma'am, is there any discovery that you're requesting from the plaintiff's office?
No, not at this time.
Okay. Then what we'll do is adjourn this matter to the court's March 5th docket at 9:15. That gives you sufficient time to file your motion, sir. March 5th at 9:15 a.m. Was there anything else on behalf of the plaintiff?
No, Your Honor.
Anything else for the defendant?
No, Your Honor.
Thank you. That concludes this matter. Have a good day.
Thanks, Judge. Take care.
Call my case. They should call my case.
I'm sorry, what?
They should call my case.
Oh, I'll call the case when you're ready.
Your Honor, which case are you speaking of?
Your case, sir.
Oh, okay. Is everybody on?
Since you're in my session talking, yes, sir.
Okay. Warren Kifferstein
This
appearing
is
on behalf.
23, I'm sorry.
2300786.
That case I'm ready to call. I was waiting for you. There were people in the breakout rooms for this case.
One attorney
And I was in the
left
middle
the
of
breakout
another,
room.
excuse me, I was in the middle of another case when you start talking.
I apologize.
So if we're ready, this is 2300786 GC Prime Home versus Ronald Rowe and Jeffrey Wilshaw. May I have your appearances, please?
Please, the court, Warren Kifferstein appearing on behalf of my client, Prime Home Remod. There should be an attorney for Mr. Wilshaw.
Yeah, good morning. Brian Marcus on behalf of Mr. Wilshaw, Jeffrey Wilshaw.
Thank you. Today is the day and time scheduled for the pretrial in this matter. How are we proceeding this morning?
Your Honor, can I give a brief history on this case?
Would you turn your camera on for me, please?
If I knew how to do it, I would. I see you. Apparently you can't see me.
Correct. If the brief history is necessary, please proceed.
Okay. Briefly, I filed a case against Mr. Wilshaw and Ronald Rowe on or about August 18, 2023. I made a motion for substituted service based upon the fact that I could not serve Mr. Wilshaw or Ronald Rowe. I got an order for substituted service. The process server, according to the order for substituted service, posted the summons and complaint on Mr. Wilshaw or Mr. Wilshaw's last known address, as well as Ronald Rowe's address. I also sent in an affidavit to the court of service that I sent the summons and complaint by mail and certified mail. I received a call from Mr. Wilshaw stating that he received the summons. He told me that I was victimizing him. I told him that I did not want to victimize him, only find out the facts. Briefly speaking, there is a lady, Ashley Sawyer, who called my client. My client went to her supposed address. She said she was the owner of the residence. She said she needed new siding on the home. My client said he could provide that. She said it had to be done forthwith. My client said he could move her up if everything had to be done forthwith, and everything had to be done forthwith because she said unless the siding was put on the residence, the mobile home would be moved from the mobile home park by management. My client started the job. He received a $12,000 deposit check after Ms. Sawyer signed the contract. The check was drawn on an account of Jeffrey Wilshaw, whose address on the check was 19429 Merriman Court, excuse me, Livonia, Michigan. Between when he received the check and did the work, he got notice that the check was not honored by the bank. I attempted to also start a case, and I did start a case against Ashley Sawyer, 23-3549 GC. I do not know her address, so I cannot serve her. I would like to serve her so that we can consolidate both cases. Ms. Wilshaw had a complaint filed by my client, a criminal complaint, which she pled guilty. I do not know what she pled guilty to, but I know the sentencing is coming up, perhaps in a week or two. Ronald Rowe has not answered the complaint. I believe a default judgment can be entered against Ronald Rowe. My client is out $22,000 for doing the work not being paid. I'd like to proceed against all parties. Ronald Rowe, Ashley Sawyer, and Mr. Wilshaw, so that we can maybe take some depositions and find out exactly where and what Mr. Wilshaw has to say under oath.
Got 1 second?
No, I don't.
Okay. I'm in Nautilus.
Is the court still there?
I'm still here, sir.
Okay. I'd like to also take the deposition of Ashley Sawyer, who I believe has pled guilty not for one count, but on 2 complaints in the criminal court. And I would like to proceed with your honorable court by continuing on with Ashley Sawyer's complaint, perhaps joining and consolidating the complaints together and proceeding to trial. Unless we can resolve this case, my client is now out $22,000.
Anything else, sir?
Nothing else, Your Honor.
Mr. Marcus?
Thank you. Your Honor, our position is that Mr. Wilshaw of Ms. Sawyer stealing a check is, and that is going to be an undisputed fact. She is going to be sentenced on February 14th for that, as well as other Mr. Wilshaw. I understand that counsel wants to do a deposition of Mr. Wilshaw. Would expect that after that deposition, and in light of the sentencing that's going to take place with regard to Ms. Sawyer, that he be dismissed out of the case because he had absolutely nothing to do with the law associated with this matter.
So, Mr. Marcus, just so we're on the same page, you're consenting to the opening of discovery that includes depositions?
Well, I don't want that to happen, but I understand that opposing counsel will want to have that done in order to properly dismiss this case against Mr. Wilshaw.
Well,
believe
today
Mr.
is the
Marcus-
day and time scheduled for the first pretrial in this matter. My notes on the file indicate that there is a complaint for $21,000, that there is an NSF check for $12,000, that Ashley Sawyer signed the contract, and Mr. Wilshaw's position through his answers that he did not authorize that check and that there was some issue with service. So all of this other conversation regarding the background of the case is, I don't know, necessary for pretrial. If the request, Mr. Kefferstein, is for discovery, the court is happy to open discovery, whether it's 30 days or 60 days is up to the parties. That's number one. Number two, if it's your indication that you want to consolidate this case with another case, the court is either waiting for a stipulation signed by the parties and submitted to the court, or a motion. Or if you want to wait until after Ms. Sawyer's sentencing date, that's something else. So when you are in the breakout room for as long as the parties were, and my question to you is, how are we proceeding? I expect to hear that there was some conversation that brought the parties to an understanding, not necessarily an agreement, but at least an understanding of how they wanted to move the case forward. So that being said, the parties both having had the opportunity to speak, the court seeing Mr. Wilshaw, defendant number 2 on the screen, the court not seeing service as to Ronald Rowe, no answer from Ronald Rowe, no appearance from Ronald
Well,
Rowe.
there was service on Ronald Rowe. You should have a proof of service and an affidavit in the file.
I thought that I saw an affidavit of non-service, Mr. Kefferstein.
There was an affidavit that I complied with the order of substituted service, and I mailed a summons and complaint by certified as well as first-class mail. The process server filed a proof of service that he posted the summons complaint on Mr. Rowe's premises, residence.
So if you want to file a default as to Mr. Rowe, please do that. Other than that, the court's inclined to open discovery for a period of time of either 30 or 60 days. Do you have a preference, Mr. Marcus?
I would say 30 days would be appropriate. Quick.
I would say 60 days in as much as I'm out of town.
I have no problem with 60 days in light of that.
Thank you.
60 days discovery, open immediately. And we'll set a return date. Of April the 16th at 9 a.m. That will take you just beyond the close of discovery. If you want to use that date as a motion date, you may.
Is this by Zoom, Your Honor?
It's by Zoom unless you want to be in person, sir.
Zoom is fine.
Zoom is good.
Thank you. Anything else on behalf of the plaintiff?
Nothing else. I just need to find where Ashley Sawyer is residing so that I can serve her.
Anything else on behalf of the defendant?
No, thank you.
Thank you. I will see you back here in April. Have a good day, gentlemen.
Thank you, too.
Thank you, Judge.
Thank you, Your Honor.
Mr. Marcus,
You're welcome,
I'll see you
sir.
soon. Talk to you soon, hopefully.
Thank you.
This is a recall of 2301788 GC Moore versus LaRouche.
Good morning again, Your Honor. Aaron Brown, on behalf of plaintiff.
Sir, would you turn your video on, unmute yourself and state your name for the record, please? Mr. Brown, were you able to talk in the breakout?
Yeah, he was able to get, so we didn't come to a resolution or anything, but I was able to speak with him, yes.
Okay, then let's send him a prompt and see if we can get him to unmute and turn his video on.
Yeah, Judge, I've been trying to do that all morning.
I
Me too.
understand. Thank you. What I will do, I'll put him in the waiting room and see if I can get his attention that way, and then I'll bring him back in. Mr. LaRouche? Mr. LaRouche?
Uh-oh.
I just moved him out again, Mr. Brown.
Okay, I thought that was him disconnecting.
No, when people see themselves
He
move,
popped,
that
we
usually
went
gets their
we went to
attention
the,
at
we went
least
to
a
the
little
breakout
bit.
room, he popped right up. I don't know.
This is 230030 GC LVMV funding versus Garaba.
Yes, good morning again, Your Honor. For the record, Paul Varchetti appearing on behalf of the plaintiff, LVNV Funding. My P number is P49403.
Thank you, Mr. Ricchetti. Today is the day and time scheduled for the motion for summary disposition in this matter. The court has reviewed the motion, has not received a response. Excuse me, that's not accurate. The court did review the motion and the response. Mr. Garaba, please turn your video on, unmute yourself and state your name for the record.
All right. Yeah, my name is Kurokwasha Gerald Garaba.
Thank you. It's your motion, Mr. Ricchetti.
Yes, Your Honor, this is our motion for summary disposition. The court indicated that you did receive a response. We have not received any response to the motion. The motion is fairly straightforward. This is a clear-cut case of a promissory note that the defendant defaulted on after filing the complaint and pretrial conference. We served the defendant with discovery, including requests for admissions. The defendant failed to answer the request for admissions in a timely manner, nor, as I said, has he filed a response that we've received to the motion for summary disposition. So outside of what's been laid out in our motion and our brief, if the court does not have any questions for me, as I said, it's a straightforward promissory note case. We would request that the court enter a judgment pursuant to the motion and brief.
Thank you. Sir, your response to the motion?
Yeah, and I responded to everything. I sent them letters. I filed it electronically. They received everything. I don't know why they're saying I didn't respond. I mailed it to them. I filed it electronically. That's why the court has it. Like, I filed it at the same time. So I don't know how they're saying they don't have it. And that's not what we just discussed on the breakout room.
Okay, sir, the motion indicated that you did not timely respond to the discovery request. Your response to the motion included the response to the request that those responses were untimely. That was part of the issue.
Yeah, I mean, I responded to everything when I got it. And you know, like, I just talked to him in the breakout room, and he said I have to contact his office to see if we can set up an arrangement. So now he's saying something different now. So I don't know what.
Your conversation in the breakout room is a matter between yourselves. What the court is asking is for your response to the plaintiff's request for entry of a judgment based on the arguments contained in their motion and the documents attached to the motion.
Yeah, I don't agree to that. I don't agree to that. Like what the document I submitted, it was a business debt that I didn't even know I didn't know it wasn't paid, and I have no, you know, the company that was still there, they're still there, but I have no information on it. And then to make, you know, and the debt is old. It's probably like 7 years old. It's past, you know, like this. It's just, you know, and then there's all kinds of problems even in their collection method. Like they broke the door of the house. They sent the letters, like the papers open. Like, I sent it all in the response, and it's like, you know, that's all a violation of the Fair Debt and Act, and also like my privacy was violated by, and I already responded to the previous company. This is just a third-party debt collector that got it from somebody, but I'd already dealt with this situation from the previous company.
Is there anything else, sir?
No.
Anything else, Mr. Burketti?
Your Honor, I just want to clarify, and look, when you go through the motion for summary disposition, this is not a business debt. This is a personal loan consolidation taken out by the defendant personally through the Navy Federal Credit Union. He made multiple payments on the debt. The last payment that was made is well within the 6-year statute of limitations. As I said, this is a straightforward promissory note case. The only thing we received, we did not receive an answer to our motion for summary disposition. He filed untimely answers to the request for admission. As such, we believe that the court should grant our motion for summary disposition as prayed.
Thank you. This court, again, having received the plaintiff's motion for summary disposition, reviewing the motion, the brief in support, and the exhibits attached thereto, and taking Mr. Garaba's response to the discovery as his response to the motion, as it's labeled at least in part, the court will grant the motion for summary disposition filed by the plaintiff. Sir, if you would submit an order to that regards, the court shows a principal balance due of,
It should show 19,454.63 plus filing fee, service fee, and statutory attorney fee, which we will include in the judgment we will submit.
Thank you, sir. Anything else on behalf of the plaintiff?
Nothing here, Your Honor. Thank you.
Anything else on behalf, Mr. Garaba?
Am I able to appeal whatever they're doing?
Absolutely. You have an absolute right to appeal the decision of the court.
Yeah, because there's a lot more going on, and it's just that, you know, maybe I have to recruit an attorney to appeal, but it's not as simple as they're making it. So.
Well, then, sir, the court will accept the judgment that's submitted by the plaintiff, sign it, and you'll get a copy in the mail. That concludes this matter. You're free to go. You have a good day.
Thank you, Judge.
This is 2302716 GC. This is Andover Farms versus Nwoko. May I have your appearances, please?
Good morning, I'm Brian Kelly on behalf of Andover Farms. I think he was here. He's I wonder if he's having trouble.
He's here.
Yeah. There we go.
Good morning.
Good morning.
Your Honor. I'm here.
Would you state your name for me, sir?
Ikechi Nwoko.
Mr. Nwoko, thank you. Today is the day and time scheduled for the pretrial in this matter. The parties have had the opportunity to speak. Mr. Kelly, how are we proceeding?
Yes, Your Honor, what we're asking for today is if we could do like a 3 or 4 week adjournment, please. I've had a chance to go through what is alleged owed with the defendant, and he's going to try to pull some bank records for me so we can match up payment history, because we think there may be some errors that need to be addressed.
Is that correct, Mr. Nwoko?
Yes, it is.
Thank you, sir. This matter will be adjourned to March the 5th at 9:30 a.m. Be back on Zoom. Mr. Kelly, is there anything else on behalf of your client?
Nothing else this morning. Thank you so much, Your Honor.
Anything
So
else,
March-
Mr. Nwoko?
March the 5th, right?
Yes, sir.
Thank you.
And the court staff will mail notice to you at the address we have on record, sir.
Oh, appreciate that. Thank you, Your Honor.
Have a good day.
You too. Thank you.
Thank you.
Have a good day.
This is a recall of 2301788 GC. This is Moore versus LaRouche.
Good morning again, Your Honor. Jeremy Brown, on behalf of plaintiff.
Sir? Mr. LaRouche? Mr. Brown, did you have the opportunity to speak to the defendant?
I did, Your Honor.
In your conversation, was there any agreement on how to proceed this morning?
Okay,
Hey, can you hear me now?
Yes. State your name, please, sir.
Mark LaRouche.
Thank you. Mr. LaRouche, you had the opportunity to speak to Mr. Brown this morning.
Yes.
Mr. Brown, how are we proceeding?
I think we're just gonna need some scheduling dates. I think we're not in any, there's not really any overlap in agreement. So I think some dates and then potentially we can come together to some solution before then. But I think our next step would be motion for summary. This one was, there was a default judgment issued and then it looks like there was an answer filed. And then now they set it for the first pretrial.
I'm looking at March the 19th. Mr. LaRouche, do you understand?
Yes, I understand.
Was that your understanding and agreement regarding how this case will proceed this morning, or was there something else you were requesting?
No, there's nothing else.
March the 19th at 10 a.m. back here on Zoom, back in number 1. Was there anything else for the plaintiff?
No, Your Honor, and that date would be dispositive motions need to be filed by then.
Correct. We call that pretrial motion for summary disposition date.
Okay, thank you. Nothing else.
Mr. LaRouche, anything else this morning?
Nope, not at all.
Thank you. That concludes this matter. You're free to go, sir. You have a good day.
You also.
Thank
you, Your Honor.
The only thing left was 224075 GC 1 Detroit Credit Union versus Stephen Ford. This case was scheduled at 9:30. It's now 10:01 by the court's clock. The court has, there are no unidentified persons in this court's main session, the breakout sessions. There's no one waiting to be admitted to the court based on the party's failure to appear. Defendant's motion will be denied. That concludes this court's docket for the morning.